Secretary of Education Betsy DeVos made an announcement today that did concern quite a few victims of rape and sexual assault. She is scrapping a memo sent out by the Education Department back in 2011 under the Obama administration, which essentially directed schools that receive federal funding on how to deal with accusations of campus sexual assault, harassment, and rape. Now, Betsy DeVos had hinted that she planned to do away with the directive, and she has done so today. First, I want to go to the video where she announces part of the reason why she made this decision. Take a look.
One rape is one too many. One assault is one too many. One aggressive act of harassment is one too many. One person denied due process is one too many. There is no way to avoid the devastating reality of campus sexual misconduct. Lives have been lost. Lives of victims and lives of the accused. And we're here today because the previous administration helped elevate this issue in American public life. But good intentions alone are not enough. Survivors, victims of a lack of due process, and campus administrators have all told me that the current approach does a disservice to everyone involved.
Break down what the approach was under the Obama administration. I'm sure some of you might have seen some coverage of this on other outlets, and none of them actually delve into the details of what the Obama administration called for. And Betsy DeVos makes some pretty heavy allegations against it, indicating that the definition for sexual assault was too broad. No, it wasn't. It was actually pretty specific. Now, it's not to say that it didn't have some problems, and we will get to those problems in just a second. But I want to be clear about one thing. Betsy DeVos is coming from a place of, hey, you know what? We're being really unfair to those who are accused, okay? So she is essentially turning the accused into the victims here, when in reality, the biggest problem that led to the Obama administration putting out that directive was the fact that in many cases, universities and college campuses refused to do a proper investigation or investigation at all when a student accused another of sexual assault or rape. So that was when the federal government got involved.
So important context here. When she says the rights of the victims and the accused have to be balanced, that's not a controversial statement. Should the accused have rights? Of course, it's America. Of course they should have rights. The question is, what do you emphasize? When the overwhelming majority of the cases turn out to be true, and you then start calling it 50-50, I'm not sure you've got your priorities straight. It's not to say that the accused shouldn't have rights, of course they should. But once you give them rights and it turns out they are guilty, and you treat it as if it's a 50-50 situation when the stats don't bear that out, that's a huge problem. The second problem is that the colleges and universities have an incentive to cover this stuff up because it makes them look bad, which then affects the people that apply, the people that come, it affects their funding. So that goes to the core of what they care about. And this doesn't acknowledge that at all. In fact, it takes the thing that acknowledged it and said, hey, don't brush this under the rug. Make sure you're treating it proportionally and in a truly and correctly balanced way. And says, no, let's scrap that. Let's not do that at all.
Right, so let me be absolutely clear about one thing. Obama's directive, or the Education Department's directive under the Obama administration, made clear that the investigation did have to be impartial. So what you just said about, so she makes it seem as though the Education Department under Obama came out and said, no, as soon as someone's accused, they're guilty, that's it. No, it said,
that's ridiculous.
Hey, you need to investigate it, okay? You need to be impartial as you do this investigation. And look, there is a different burden of proof when it comes to a criminal case. So if this alleged rape, for instance, goes to trial and it is a criminal case, the burden of proof is much higher. That person needs to be found guilty beyond a reasonable doubt because that is a serious allegation and you're talking about a criminal offense. When it comes to a college campus though, they're not lawyers, there's no judge, this is not a criminal system. This is a university making a decision as to whether or not this rape happened, and if it did happen, has it created a hostile environment that distracts the victim from learning and feeling comfortable on campus, and then the university decides what it should do. But again, the burden of proof is a little lower for the universities because we're not talking about a criminal case, we're talking about a university in doing their own investigation to figure out what's best for those involved.
All right, one more piece of context, because if you're saying, aha, I knew it, it's a lower burden of proof, that's they're railroading these guys. It should always be an incredibly high burden of proof. No, there's different contexts. For example, civil trials. Civil trials don't require you to be 98% certain, 99% certain. They just require you to be 51% certain because you've got to decide who's right, who's wrong. So you might or might not remember this. So OJ, of course, got acquitted. Everybody remembers that in his criminal trial. But then the Goldman family, who lost their son, sued OJ in a civil trial. And they won easily because it was a different burden of proof because he likely did it. It's just in the criminal trial, they couldn't prove it beyond a reasonable doubt.
Right, so again.
So in some contexts, it makes perfect sense to have a different burden of proof because they're not lawyers and justices and judges at the university, and they've got to make a decision who's right, who's wrong, how do we make sure there's the least amount of damage here?
Right, and again, these are school officials who do not have the power to convict someone of a felony, which is why the burden of proof is lower. And by the way, the burden of proof is still very high because they have to, through their investigation, find that the person who has been accused more than likely did it. Okay, so again, it's a lower burden of proof, but they have to provide evidence indicating that this individual more than likely did it.
I'm just gonna say one last thing, because these like you might be hearing right-wing propaganda out there, and they make it seem like, all you have to say is, he did it, and then they kick you out of college. It's not remotely true. They go through an entire long process because nobody wants to do that. Nobody wants to take a kid who didn't do it and go, I don't know, somebody said it, so what? Let's just throw it out. By the way, on this show, we've defended many people who we thought didn't do it. And there was big debates about the mattress woman at Columbia, and I think she was preposterous, and I don't want to get back into those debates. Of course, as progressives, we value the rights of the accused. But you also have to make sure that you're protecting the women on campus and men if they're being sexually assaulted.
Right, and there is a percentage of men who do face sexual assault on campus as well. So this isn't just a female victim issue. Now, back to DeVos, I want to go to graphic 3 to give you a better sense of where she stands on this. She says that those that use a system bias toward finding a student responsible for sexual misconduct are also committing discrimination. DeVos suggests that the definition of sexual assault is too broad and too many cases involve student and faculty simply for speaking their minds or teaching their classes. That is patently untrue. And again, I'm gonna reiterate, if you've seen coverage of this story anywhere else, they never get to the details of what that directive said. So it was 20 pages long. I wanted to make sure I read every word to really understand it and give you guys the facts. So let's get to that.
Okay, sorry, one last thing there, because that statement shows you what DeVos is about. Because when she says, let's be balanced, that there's no harm in saying that, of course you should be. But when she says that you could be accused for just saying words, that's just not true. That shows you she has bad intent. She's purposely lying about what the policy says. Look, I was a conservative when I was on college campuses, and I remember one time somebody said that I should not be allowed to speak in class because I was such a large man that my words intimidated them. Okay, so I fought that nonsense. And by the way, you know what the liberal dean said at the college? That's nonsense. Of course you're allowed to speak. Doesn't matter how large you are. I mean, how preposterous. We're never gonna agree to stuff like that, but that's not what the policy does. DeVos is lying about it.
Now here are the relevant portions of the memo sent out by the Education Department back in 2011. Now they did define sexual violence rather specifically. They said sexual violence, as that term is used in this letter, refers to physical sexual acts perpetrated against a person's will or where a person is incapable of giving consent due to the victim's use of drugs or alcohol. An individual also may be unable to give consent due to an intellectual or other disability. So that is what we're talking about there. And I don't know, I mean, I don't consider myself that smart, but I understood the specific definition laid before me that describes exactly what the sexual violence is and what the university is expected to investigate should a complaint come forward. Now,
maybe she's twisting it on purpose. Well, if the woman says no and you rape her anyway, and then they say, well, I mean, what are you just punishing the guy for language just because she said no? He was supposed to stop. Is that the point of her mentioning language? I mean, come on, man.
So what did this letter tell universities that receive federal funding? What did they tell them they need to do? Okay, so they laid it out. Here are the bullet points. Disseminate a notice of non-discrimination. Essentially, let everyone on that campus know we're not going to discriminate against you based on your gender, your sexual orientation. That is standard Title IX requirements. So there's nothing controversial about that. Designate at least one employee to coordinate its efforts to comply with and carry out its responsibilities under Title IX. So just hire one person who actually carries out the responsibilities of Title IX, one person.
Well, if you're gonna change that, I know you're not gonna go up. The only other number is 0. So is that a balanced approach? Ridiculous.
Adopt and publish grievance procedures providing for prompt and equitable, I'm gonna repeat that again, equitable resolution of student and employee sex discrimination complaints. Okay, so where is this like overburdensome for universities? Because again, the reason why this letter was sent out by the Department of Education was because there was an increasing number of women coming forward and alleging that their universities refused to even investigate it. And so what the Education Department said was, hey, look, we want you guys to do a thorough and prompt investigation and find a solution or resolution, okay? You have to do that because you don't want to create an environment where students don't feel safe. Now, here's another thing that I want to read to you, and again, this is exact wording from the letter that was sent out. The school's inquiry must in all cases be prompt, thorough, and impartial. In cases involving potential criminal conduct, school personnel must determine, consistent with state and local law, whether appropriate law enforcement or other authorities should be notified. Oh, this is just, I mean, look, it's just, they're gonna find people guilty immediately as soon as they're accused. That's what this letter was all about.
Anna, Obama administration, by demanding impartiality, obviously meant be biased.
No, but here's the thing, okay? This administration, this current administration, just wants to undo anything that Obama did, right? It doesn't matter if the Obama administration had executive orders or passed or pushed for legislation that made sense and actually made people's lives a little better. Doesn't matter if it's climate change, doesn't matter if it has to do with sexual assault on college campuses, doesn't matter if it has to do with the LGBT community being allowed to join our military. Doesn't matter how much sense those policies made. The Trump administration hates the Obama administration so much that they just want to undo anything that he did with no rhyme or reason.
No, but Anna, to be fair to them, they're also right-wingers and they believe this stuff. They think sexual assault, the balanced approach to that is maybe having 0 people look into it instead of having 1 person looking into it. And so, you say tomato, I say tomato. You say it was sexual assault because she said no. I say, well, are you really being fair to the guy? So, and Betsy DeVos looks pleasant, and she went to her nomination hearings and was like, oh no, I'll be so fair. Ben Carson did the same thing, Gorsuch did it for the Supreme Court, and the press talked about how pleasant they looked and the pleasant words that they said. It doesn't change what their policies are. Their policies are oftentimes barbaric. And so the minute they have an opportunity to implement it, they're gonna implement it. And so then don't vote for Republicans if you are gonna send your daughters to college and you're worried, or your sons, and you're worried what might happen. So, and don't get surprised when they do, because this is what they believe in. Support independent media. Come join us at the Young Turks. TYTnetwork.com/join.